What is the most important requirement to prove or disprove something inside the court? It is the evidence. Yes, evidences are the most crucial requirements to prove or disprove something inside the court. Now, when one party is busy in proving its evidences, the adverse party will always be busy to prove that those evidences given by the other party are not valid. Now, when we are discussing that particular aspect, section 155 plays a very important role where we are understanding the concept of impeaching the credit of witness. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were focusing on chapter 10, which is all about examination of witness, and in that series this is my 14th video where we are going to understand the concept of impeaching the credit of witness under section 155 with the help of chart as well as illustration. Not taking much of your time, let's get into the first slide. Section 155 discusses about impeaching credit of witness, and before I get into my chart, I would like to quickly read out the Bare Act provision which says the credit of a witness may be impeached in the following ways: by the adverse party or with the consent of the court, by the party who calls him, subsection 1, by the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit, subsection 2, by proof that the witness has been bribed or has accepted the offer of a bribe or has received any other corrupt inducement to give his evidence, subsection 3, by proof of former statements inconsistent with any part of his evidence which is liable to be contradicted, and subsection 4 is repealed by the 2002 amendment. This is a very important aspect you need to remember. If you ever see subsection 4 of section 155, remember that this has been repealed with 2002 amendment, which was when a man is prosecuted for rape or an attempt to ravish, it may be shown that the prosecutrix was of general immoral character. Now this subsection is no more. This is a very important aspect you need to remember, and that is also shown in my chart. And finally, there is an explanation which says a witness declaring another witness to be unworthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reasons in cross-examination, and the answers which he gives cannot be contradicted, though if they are false, he may be afterwards be charged with giving false evidence. Now all of this I have brought into chart in my next slide. Let's quickly go through that. Before getting into chart, we need to understand that there are several other sections which are connected to section 155. Like for example, section 140 which speaks about witness to character. Section 145 discusses about cross-examination as to previous statements in writing. Section 146 specifically the subsection 3 which is about the shaking of the credit of the witness by injuring his character under this section 146, where we are discussing about questions lawful in cross-examination, and section 154 asking questions to own witness, that is the concept of hostile witness. All of these are very important provisions that we need to remember. Before going any further, we need to understand what is impeaching. That is a very important requirement. Now, when one party is trying to prove its evidence with the help of a witness, the other party says the witness himself or herself is not trustworthy, because there will be several reasons. Now those several reasons are discussed under section 155, and by giving those reasons, the adverse party is trying to prove that the witness is not trustworthy. By saying that, the adverse party says that the witness given by the witness or the evidence given by the witness is not creditworthy. If that is attempted, that is known as impeaching credit of witness. The simple meaning of the term impeachment is the action of calling into question the integrity or validity of something. here the integrity of the witness itself is asked and said he himself is not trustworthy, and in that case how can we take his evidence? That is what discussed under section 155. Here the adverse party challenges that the witness is not creditworthy or trustworthy. That is what we are going to understand under section 155. There are several ways to say that, and that's very clearly mentioned under section 155. The chart goes this way. The credit of a witness may be impeached by adverse party or own party with consent from the court. Till here, we have few important aspects to be observed. The first thing is the credit of a witness may be impeached, which means the parties have discretion for impeaching credit of witness or not to do so. Now, it is the discretion of the parties. When I say discretion, adverse party has such discretion straight away, but if the own party which calls the witness wants to do impeaching the credit of witness, that needs to take the consent of the court. Now remember, for the own party, this section is the continuation of section 154. That is a very important aspect one need to remember. Now I will not spend any time on section 154 because that is a big concept which we have already discussed in my previous video. Now how to impeach? There are three important subsections under section 155 and let us try understand them one by one. Now subsection 1 is about the evidence of persons who testify that they from their knowledge of the witness believe him to be unworthy of credit. Now how to understand subsection 1 of section 155? I will give a simple illustration. Imagine A is the witness. He has given some evidence to the court. Now the adverse party calls B, C and D, and all of them are saying that A is not trustworthy. Now such persons are living with A and they have seen A. Living with A means they are living in the same society. They have seen A, they have experience and knowledge with A, and on the basis of their knowledge they are giving evidence to the court that A is unworthy of credit. If that is done, that is one of the way to impeach the credit of the witness under section 155. Subsection 2 of section 155 is very easy. Whenever there is a proof is given that the witness has been bribed or the witness has accepted an offer of bribe or has received any other corrupt inducement, by giving those evidence, the credit of witness can be questioned under section 155, that is subsection 2. The third subsection is quite easy. Here what happens, a particular witness gives two different statements and when you compare them, there is inconsistency available. By giving proof of such inconsistency, the impeaching credit of witness can be done under section 155. If you remember, we have discussed similar concept under section 145 where we understood cross-examination as to previous statements in writing. Remember, section 145 is limited to writing, whereas section 155 gives further advancement to impeach the credit of the witness on the oral statements also. Here, both oral as well as written documents can be contradicted if there is inconsistency between the former statement as well as the current statement. That is what we need to understand from this particular subsection. Subsection 4, as I have already told, is being amended and repealed, so that is not available as of now, which is a very important aspect everyone needs to remember. Before going to the illustration, we have one very important explanation under section 155 and let us try understand that with the illustration that we have already discussed. I told A is a witness, B, C and D are coming to the court and say that A's evidence should not be considered because he is unworthy of credit. Now when B, C and D are saying this particular aspect, the party which has called them during examination in chief, it will not mostly ask that why or how are they saying so. They might skip that part, but cross examination will definitely ask them. They have the right to ask them that how can they say so. Now there B, C and D will give their own reasons. On that there cannot be any contradiction done. There will not be any further evidences taken on that particular aspect. But if the adverse party feels that B, C and D are giving false evidence, they can definitely put a case according to section 193 of Indian Penal Code for false or fabricated evidence. That provision is available as per the explanation, which is what you need to understand. We have two illustrations under section 155U and let us try understand them one by one. The first one is very easy. There are three people A, B and C. Now A says that he has delivered certain goods and B has to pay for the same. Now C comes to court and says that those goods are delivered by him to B. He says it is not A, but I have delivered those goods to B, so B need not to pay anything to A. That is what C says. But there is a proof available that C earlier has told that he has not delivered any goods to B. Now evidence given for C's such statement, and once after giving evidence to C's such statements, those evidences will be admissible. Here what are we seeing? Subsection 3 of section 155U. The earlier statements versus the current statements, and they are inconsistent. Here because C earlier said that he has not delivered, but now he is saying that he has delivered, there is contradiction available. So evidence can be given against his such statements, which is what we need to understand. In the second illustration also there are three people A, B and C. A is the accused of the murder of B and C is the witness who is saying that B before dying declared that A has caused him certain wound and because of such wounds he is dying. Basically a case of dying declaration. But here an interesting aspect is there is an evidence available that C earlier said that wound was not given by A or in his presence. Now C's statements are inconsistent, so evidence is admissible for such statements, and that is what discussed under subsection 3 of section 155. To understand section 155, there is one judgment that you should read, that is Sri N. Sri Rama Reddy versus V.V. Giri. This judgment is mostly about section 155. Throughout the judgment you can see reference to section 155 and I insist you guys to read that particular judgment, and with that I am handing over this presentation to Nishan.
If you are in confusion, don't hesitate to ask for suggestions from your friends and families. With that, I am concluding this session.